think she ended up getting fired from that job too.
Well, it was a little more complicated, but basically, yes.
We're going to go ahead and get started.
Thanks for sharing.
Okay, we're going to go ahead and get started. My name is Jean Peters, and on behalf of Wood County Indivisible, I want to thank you all for attending this forum tonight. Before we begin, I'd like to explain the format of the forum and set a few community rules for conduct for all of us tonight. We're going to begin with presentations from our three panelists, followed by questions I will offer the panelist as the moderator, and we'll conclude with questions from the audience for our speakers. We expect that all participants and audience members will conduct themselves with civility, respect, and decorum this evening. There'll be no speaking out of turn, no name calling, no shouting. I promise to recognize all people who have a question when they raise their hands after we finish the moderated questions. For clarification, I'm going to begin by reading the exact wording from the ballot on constitutional amendments, which should be in front of you. If anybody does not have that, they're on the back table. Amendment number 1, Constitutional Right to Abortion Amendment. Summary of purpose: to amend the West Virginia Constitution to clarify that nothing in the Constitution of West Virginia secures or protects a right to abortion or requires the funding of abortion. And that's the extent of it. Now, please join me in welcoming our panelists to the forum, and let me give you a brief introduction of each of them. Walt Oval practices at the Employment Law Center in Parkersburg, West Virginia. He's a graduate of the WVU College of Law. He was the first West Virginia lawyer to be made a fellow of the College of Labor and Employment Lawyers, excuse me, a professional association honoring leading lawyers nationwide in the practice of labor and employment law. Oval is the chair of the West Virginia State Bar Employment Law Committee. Oval is a founder of the West Virginia Employment Lawyer Association, the state affiliate of the National Employment Lawyers Association. Walt is a member of the Board of Directors of Workplace Fairness, a national nonprofit organization, and he has been named one of the top 10 lawyers in West Virginia, and I thought it was over this. Angelita Nixon, Angie, is a native of Indiana. She received her BA in psychology from Macalester College in Minnesota, and her certificate of professional nursing and MSN from Case Western Reserve University. Prior to 2003, Angie spent her women's health professional life practicing full-scope midwifery in level 1 and level 3 hospitals, clinics, and a freestanding birth center. In 2003, Angie became a small business owner, opening her own private practice specializing in physiologic birth at home, serving families in West Virginia and Ohio. Active in the leadership of midwifery and nursing professional associations at the state and national levels, Angie contributes to the work of the West Virginia Perinatal Partnership to address parent-child health, build collaborative networks, and engage in public work policy. She enjoys mentoring new leaders, especially within the West Virginia ACNM affiliate, where she is currently legislative co-chair and previously served in all officer positions except treasurer. Okay, and Sue Ellen Waybright, right here, is a retired accountant with over 35 years experience in both private and public sector, and a former adjunct professor at WVU Parkersburg. Ms. Waybright currently volunteers with the Circles campaign of the Mid-Ohio Valley, advocating for low-income individuals and families and against issues and policies that will hurt them. Ms. Waybright understands these issues because she grew up in a poor neighborhood here in Parkersburg and faced many of the challenges they face today. And with that, I would ask you all to welcome our panelists who are giving up their time this evening. And I'm going to turn the podium over to Walt.
Good evening, everyone. Welcome. It's a great turnout, and I'm a little surprised to see this many folks, and I'm happy to see this many folks. And I don't know quite everybody, but in West Virginia, I know almost everybody. So welcome to everyone who's here, regardless of whether you have a stand on the issue or not. So I'll keep my presentation on the legal issues regarding this amendment brief, and so that we can hear from the other folks who probably have a lot more interesting things to say about it, and also hear questions and answers both from our moderator and from the audience, which I look forward to. So to repeat, because it's brief, the constitutional amendment, which is on the ballot, constitutional amendment number 1, you as a voter will be asked to either vote for or against. So those are your options as voters. The amendment would add an article to the West Virginia Constitution which would say that nothing in this Constitution secures or protects a right to abortion or requires the funding of abortion. You will note in the very brief language of that amendment that there is no reference to the life or health of the mother, nor is there any reference to rape, nor is there any reference to incest. So, I mean, that's apparent from the language. So it has to be put on the first shelf. The second shelf of our bookshelf that we're building on this legal issue is, what is the current state of the law with regard to abortions generally in West Virginia? West Virginia Code defines the following as a crime, and this is West Virginia Code 6128, abortion penalty. Any person who shall administer to or cause to be taken by a woman any drug or other thing, or use by any means, with intent to destroy her unborn child, or to produce abortion or miscarriage, and shall thereby destroy such child, or produce such abortion or miscarriage, shall be guilty of a felony, and upon conviction shall be confined in the penitentiary of not less than 3 nor more than 10 years. And if such woman die by reason of such abortion performed upon her, such person shall be guilty of murder. No person by reason of any act mentioned in this article shall be punishable where such act is done in good faith with the intention of saving the life of such woman or child. This statute was held unconstitutional by the federal courts in a 1975 case, which followed, if you'll remember, immediately after the Roe versus Wade case, and relied upon Roe as the basis to find the West Virginia criminal statute unconstitutional. So, what, if any, effect would the passage of the West Virginia constitutional amendment have on the law in West Virginia? Well, it would have 2 effects. The first relates to this criminal law. Although this criminal law has not been taken up by our West Virginia Supreme Court, a decision which was later rendered by our West Virginia Supreme Court makes it clear that under West Virginia constitutional law, this statute could not be enforced as things stand now criminally in West Virginia, because of a decision regarding a different issue. But that decision of the West Virginia Constitution would no longer be effective if this constitutional amendment passes. The constitutional amendment cannot affect the federal case, however, because that federal case was decided under federal law under Roe versus Wade. Consequently, upon passage of this amendment, this criminal law would not become immediately effective. So I don't want anyone to misunderstand my position regarding that. There would not be an immediate criminality of abortion in West Virginia upon this statute being, or upon this amendment being passed. So to that degree, folks who have supported the amendment are correct. However, one must understand also that Roe versus Wade has been considered by our United States Supreme Court several times. And in each of the most recent decisions, the fundamental decision of Roe versus Wade, which upholds a woman's right to abortion under certain circumstances, has been upheld by a 5-4 vote. As everyone knows, we recently had an addition to the United States Supreme Court, a controversial one, added, and of course we have not had in that brief time, Justice Kavanaugh having only been on the bench not even a month at this point, we have not had another decision rendered by this current Supreme Court. However, Given the past record of Justice Kavanaugh, or now Justice Kavanaugh, it's certainly believed by, I think, most folks that there will be a substantial chance that Roe versus Wade will be overturned when it's finally considered by this current U.S. Supreme Court. If that happens, there will be no protection under West Virginia law for any abortion. The criminal statute that I read has no exception here for rape. It has no exception for incest, and it would make any abortion a crime unless the individual could prove that the abortion was done, as it's said in the statute, in good faith with the intention of saving the life of such woman or child. Now, the issue before us at this point would be what determination would be made regarding that, who would make that determination, and obviously it could put providers, such as nurse midwives, obstetrical providers, women, in a very serious position with regard to their health and their lives. One example of that, which probably our nurse midwife could speak to more, would be an example of ectopic pregnancies. That's a subject that's come up, and it's one that's quite common, actually. And those also are called tubal pregnancies. Those are very common and are situations in which there is no potential viable fetus. It's not a life-threatening situation. It's a situation which, absent the termination of the fetus, will certainly cause the death of the mother and poses, under this statute, a very serious question as to whether the result would be either a criminal violation or the death of both the fetus and the mother. So that's where we stand. I want to now turn to another issue, which is the issue of public funding. The issue of public funding of abortion was decided by the West Virginia Supreme Court in a decision over 20 years ago now, in which the West Virginia Supreme Court said that under West Virginia constitutional law, it was illegal for the state to provide medical care for indigent poor folks who qualified for Medicaid without providing abortion services to those poor individuals, those people who could not afford it, on the same terms that they were available for other people. The legislature didn't like that. It passed a statute basically saying that that was not the law, and the West Virginia Supreme Court said that statute was unconstitutional. One effect that this amendment would have immediately is that it would overrule that Supreme Court decision, and it would immediately make public funding for Medicaid abortions illegal in West Virginia. So to that degree, the supporters of this amendment are correct when they say that that is an effect it would have. So you hear that the argument is made continually, and I think, obviously for good reason, by those who support the amendment, that they do not want to provide public funding for abortion. They do not want to have public funds used in that way. And that currently is something that the West Virginia Supreme Court of Appeals has said is required under West Virginia constitutional law. It's important also to know, however, and I'll wrap up, that the issue is of public funding was considered in the legislature. The legislature was given the opportunity, when this amendment was considered, to limit the amendment to that issue, and to say that the only thing on the ballot would be the issue of whether or not public funding should be or could be used for abortions. The legislature rejected that approach. They rejected the idea of limiting this amendment to that issue, and instead made the amendment, as you see, broad enough that it eliminated any right to abortion under the Constitution under any circumstances, regardless. So that's the legal lay of the land, and I'll turn it over to the next speaker.
Thank you so much for giving us the legal perspective on that. We appreciate it, Walt. And I'm going to go ahead and turn it over to Angie, who's going to discuss the medical implications of Amendment 1. Thank you.
Thank you, Jean. I'm Angie Nixon, and just briefly, I'll just give you a quick overview, a little bit about midwifery. I have been practicing midwifery my entire career in West Virginia. I moved here in 1999, straight out of grad school. And a lot of people associate midwifery care with pregnancy care, which is definitely part of what we specialize in, and probably the part of healthcare that we specialize in the most. But we also do provide services for women's health across the lifespan. So from the very beginning of first having exams, needing exams, to the very end where we're doing menopause care, and a lot of primary care as well in there is within our scope. It is also within our scope to practice abortion care. And I can really appreciate the nuances of what that means in terms of what families need in our culture today. I'm personally a little bit uncomfortable with some of the labels that we use when we describe what our positions are on things, and it's difficult until I bring it back to the healthcare context, because that is, what does this individual person need at this individual time and in this individual context. And that takes a lot of individualization in order to help make good decisions during those times. And there are a lot of diversity of opinion about these ethical considerations. So why I got interested recently in the issue of abortion care across the world was when I attended my first international midwife conference in South Africa. And the theme of the conference was the top 5, the big game, big game 5 animals, game animals that can kill a human. And the theme of the conference was the big 5 for what are the most prevalent causes of maternal mortality around the world, what kills women in pregnancy, particularly in specific. And the top 5 reasons for maternal mortality across the world haven't really changed a lot over time. And you'll see that these things still persist, and they're some of the hardest things that we have to get over as far as getting to address the preventable causes of maternal mortality. Hypertensive disorders, infectious disease, hemorrhage, prolonged labor and birth disorders, and unsafe abortion. And up until that point, I sort of had not really considered abortion to be a top cause of concern in my life, in my practice. I was not an abortion provider. But I did care for a lot of women who were having planned pregnancies, desired pregnancies, who developed complications in their pregnancies that turned into situations that they did need to consider the option of terminating pregnancy for their own health reasons or for other reasons that were beyond the elective procedures. But it did raise my consciousness about that issue, that it is one reason that women die. And it's not just a small reason, it's one of the top 5 contributors. Since about 2010, West Virginia created a panel that's now called the Infant and Maternal Mortality Review Team. And I serve on that team. And we review every maternal death that happens in the state. And we have been, I think it went back to about 2007. And we found that the same causes worldwide of maternal deaths are prevalent in West Virginia as well, and also include mental health disorders, specifically substance use disorder and overdose, homicide, cardiomyopathy, which is not exactly a hypertensive disorder, but it does relate closely with hypertension, and self-inflicted harm. So these were also eye-openers to me of reasons why this is pertinent in healthcare. So the majority of women that I work with are healthy women, and they're happy with their pregnancies, but occasionally there come times when they do also need to consider termination if the fetus is carrying a fatal defect, is one of the common reasons that I've cared for women in my own personal practice. A case where a baby is developing without any brain tissue, basically, anencephaly is the cause. And that means that there may be a brain stem, but there's not a functional brain. So a lot of those pregnancies end up going overdue, and labor is never spontaneously initiated. I had another client who had multiple defects in her fetus, and she was devastated that there was no chance that the baby was going to survive. And she decided that she needed to terminate the pregnancy. In her mid-pregnancy, around 23 weeks, there was no place that she was able to do that in West Virginia. So she had to travel to Ohio to seek abortion care there. And when she did, she sought care in a facility that had protesters outside. And they yelled at her and her husband as she walked into the clinic and told her that she was, they yelled cruel things to her. And she just wished that they understood that she wasn't terminating a pregnancy that she didn't want. So that was a difficult situation for her. And it's those cases that are so hard for me as we're looking at this spectrum of issues that come about when we're talking about women's access to healthcare decisions, that they should be able to make themselves with their family's involvement and their healthcare providers, clearly. Ectopic pregnancy, which has also been mentioned, is another scenario. Ectopic pregnancies are pregnancies that do not occur inside the uterus. And so they're non-viable pregnancies. There's no possibility that they can develop and produce viable children. So that is another case, and those are often situations that can occur very quickly, that they can become complications, and women need prompt access to services for their health as well, because otherwise it may lead to another problem, hemorrhage, which is in the top 5 list of killers of women. I also cared for a woman who had attempted to terminate her own pregnancy with use of herbs. And she was fairly desperate in that, but she had also done a lot of research, and she had tried to take the situation into her own hands. When she failed to miscarry from that, she did seek care in an abortion clinic, and she was told that she had a twin gestation. And so in her mind, she had the herbs possibly could have helped her. And if it had been a singleton pregnancy, there's no way to know for sure, but she did end up completing the termination procedure from a medical perspective. And that just goes to show the desperation and lengths that women will go to if they don't have access, or for whatever reason they don't feel that they can safely access the care that is currently available. So I did just want to kind of introduce these issues from a healthcare perspective. I don't have anything else that I specifically wanted to present to you at this time, but just to give you a little bit of an idea of the nuances of some of these issues that are really complex.
Thank you very much, Angie. And now Sue Ellen Waybright will speak to us about some personal experiences, as well as look at the economic issues around unwanted pregnancies.
Thank you, Jean, and thank you for everyone who came out tonight.
Really close to
Really close?
Yes.
Okay, now I get the feedback. I know you're hearing me. Jean asked me to speak because of a story that I told her earlier in the year when this first amendment was first passed. And it's not a story that I've told often or have just thrown out there. I come from a generation before Roe was law of the land. And I want to tell you about one of my classmates. It was in the spring of 1969, and I think it was May, because I was looking forward to graduation in June. And I worked on the PHS Journal, which is the school newspaper. And we had such a thing whenever we put the school newspaper out that everybody had to come on the night that the paper was put to bed. That's what we called it. Everybody had to be there regardless of which journalism class you were in. Everybody had to be there. And somebody noticed, and I'm going to call her Kathy, wasn't there. And we asked why. You know, everybody, it was understood everybody had to be there. Keep in mind, I was 17 at this time and Kathy was 16. And our brand new substitute teacher who had just graduated from Marshall University told us that Kathy was in the hospital. She had nearly bled to death as a result of a self-induced coat hanger abortion. That was a hard thing to hear. I learned more in that journalism class about sex education than I did in 3 years of health class at the high school. She nearly died. She nearly bled to death. That was a wake-up call. I had to ask myself, it was not sexually active at the time, what would happen if I got pregnant? How would I handle it? What could I do? What would I do? As Jean said, I grew up in a poor neighborhood here in Parkersburg, and the options at that time were very limited. I feel for Kathy. I cannot imagine the desperation that she felt. She was not from a wealthy family. She was not one of the so-called sluts of the high school, just an average student. And like I said, it was a wake-up call. The second story I'm going to tell you is the story of one of the students that was in my speech class at WVU Parkersburg, who came to me and confidentially confided in me that she'd had a medically necessary abortion. And she had been very open about her health conditions and her very obvious physical limitations. And she told me she had become pregnant earlier in the year and had had a medically necessary abortion. And understanding her physical limitations, I can understand why, if she had carried that baby to term, that it probably would have cost her her life. Women need to have these options available. We cannot go back to the days of coat hanger abortions. Thank you.
Thank you, Sue Ellen. I'd like to have another round of applause for all of our speakers who have shared their time with us. And I have some additional questions for y'all that have been presented by various members of the community. The first one is for Walt. There's been some confusion around the Panepinto decision, the 1993 decision that you discussed. And according to the materials that I read, Justice Workman made the determination that this was, that if we were going to provide care for pregnancy under Medicaid, we also had to provide medically necessary abortions under that decision. Did the Panepinto decision also allow for elective abortions or abortions on demand, or simply medically necessary abortions?
Can I just speak from here?
Yes, please.
Okay, so again, this deals with the West Virginia Legislature's 1993 Act, which is at West Virginia Code 9211, which is titled Limitation on Use of Funds. This provision of the law deals with the use of Medicaid funding. For those of you who know, I mean, I figured most folks know what Medicaid funding is, but just in case, this is funding for those who meet certain income levels, which are basically almost nothing in West Virginia, but basically very low income folks to provide some forms of health care. The legislature in 1993 provided that the Medicaid program, and I'm quoting from the statute, not provide coverage for abortion on demand, and that abortion services be provided only as expressly provided in the section. And the section had a number of criteria, including medical emergency, clear medical evidence. It had all kinds of tests and different things that were applied. That's the law, the statute that existed. In 1993, after the statute passed, it was challenged in the West Virginia the West Virginia Supreme Court, and the relevant provision of the Panepinto, as it's called, and for anybody who's really into this stuff, I can give you the spelling. It's Women's Health Center versus Panepinto, a 1993 West Virginia Supreme Court decision. The key finding of that decision was that, and I'm quoting from the Supreme Court, given West Virginia's enhanced constitutional protections, and that's the critical link between that decision and this amendment, given the West Virginia's enhanced constitutional protections, we conclude that the provisions of West Virginia Code 9211 constitute undue governmental interference in violation of the state's obligation to act neutrally with regard to the exercise of the federally protected right to terminate a pregnancy. So the core of the Panepinto decision was to say that the legislature had not acted neutrally with regard to poor West Virginians in affecting their exercise of the right created by Roe. That's the key issue. And it did not require funding of any abortion other than medically necessary abortions. It's kind of a house of cards in this sense. And what I mean by that is the Panepinto decision relied on a right that was created by the Roe decision. Absent Roe, arguably Panepinto has no basis to exist at all. So, I mean, cue ball, 8 ball, 3 ball on that one, if you understand my thinking.
Thank you. I think that clarified it. I want to follow up with something that Angie presented to us. Talking about ectopic pregnancies, are those rare occurrences?
I can't quote you the exact incidence of ectopic pregnancies, but it is one of the most common causes of acute complications of a pregnancy, sometimes even before a woman knows that she's pregnant.
And so in those situations with a medically necessary pregnancy, especially I think about ectopic pregnancy because I've had friends who've had them, how quickly can the health of the pregnant person be endangered if they're not able to terminate?
That can happen in a matter of hours.
Okay. And it's fatal?
The complications that can result from it, yeah, definitely, that's definitely life-threatening.
Okay. Thank you very much. Back to Walt. Recently, a Michigan pharmacist refused to fill a prescription for a woman who suffered a miscarriage in July. Her doctor prescribed misoprostol, did I get that correct? Okay. Which she was told was, quote, crucial for her to take in a timely manner to avoid having to undergo a more invasive surgical procedure. Misoprostol can also be used to induce labor, treat ulcers, and terminate a pregnancy. She was refused that prescription by the pharmacist. Would the adoption of Amendment 1 affect which medications healthcare providers are legally allowed to prescribe in the state of West Virginia? And I'm going to pass this to Walt and then back to Angie since she has experience in this realm too.
Well, going back to the immediate issue, the passage of this would not immediately affect that in my view, because until Roe is overturned, there would still be protection under West Virginia from criminal prosecution under the Doe case, which was the case that I talked about earlier that followed Roe in 1975, holding the criminal law unconstitutional. However, to the extent that Roe is overturned, and therefore Doe would be overturned as well, and abortion is recriminalized under this West Virginia Code 6128, it specifically says that any person who shall administer to a woman any drug or other thing with the intent to, quote, destroy her unborn child, goes on from there, produce abortion or miscarriage, shall be confined to the penitentiary and so forth. So certainly, if that criminal statute were to be in effect, there would be, of course, and once Roe's overturned, no federal protection. Under West Virginia Constitution, if this amendment passes, there would be no state protection. So that pharmacist certainly could be prosecuted and convicted of a felony.
This has come up in a number of contexts. One is about ethical care, and in my professional association, the American College of Nurse Midwives, we do have guidelines for how to manage when a provider has an ethical dilemma over care that a patient needs. And generally, it is considered that professionals are held to the standard of if they're not able to, by their own conscience, provide care that's required by society, that they make a referral to another professional who could ethically do that. And so it's really, I find that it's becoming more and more of an issue in areas of women's health, specifically with this, you know, the pharmacist is not always the most qualified person to determine whether or not a person should be taking any certain type of course of care treatment. I've seen this come up with the provision of emergency contraception before it was made available over the counter, that it just elaborates that there is a basic misunderstanding of the physiology involved in how a person would conceive a pregnancy. And that is a concern that we have too, that you know, we do have a contract with society as a professional healthcare provider that we do provide services regardless of our own personal views of what necessitates any given medication, treatment plan, etc. So that's where there's a little bit of a thorny issue with that.
Thank you. And Sue Ellen, I'm not meaning to neglect you over there. In your experience, because you work with people in poverty, that is your area of expertise and where you volunteer your time, can you elaborate for us on the effect of unwanted pregnancies on families or individuals already struggling with economic crisis?
Sure, Jean. A lot of it depends on the woman's situation, and everyone's situation is different. But imagine, if you will, a 16-year-old who gets kicked out of her family home because she tells her parents that she's pregnant. She's out on the street. She has no income. She has no housing. She has no support. Where does she go? What kind of help can she get? There are agencies out there that, yes, they will help, but she's still going to find a struggle. If she hasn't graduated from high school, she may or may not drop out, and if she drops out, she has to go back and get a GED. Without a GED, she's not going to get even a minimum wage job in these days, because more and more education is required no matter what field you go into, and that limits her earning ability. Now, I pulled some statistics for you today. This is from the U.S. Census Bureau. 2017, the average poverty threshold for one person is $12,488. For two people under the age 65, that goes up to just under $17,000. If you become a single mother, you're going to have to earn a living if you do not have any family support or support from the father or other financial support such as from the state. To put this in perspective, the minimum wage in West Virginia is $8.75 an hour. Most of our folks that I work with are lucky if they can get 20 hours a week in a part-time job. That gives you an annual salary of just over $9,000 a year. It's a little hard to pay rent, and I'll get into that in a minute, buy food, buy clothing, get food and all the necessities of living on your own without support. The National Low Income Housing Coalition estimates that anyone working in West Virginia at our minimum wage of $8.75 would have to work 53 hours a week to afford a one-room apartment here in West Virginia. That's based on rent being 30% of your income. That still doesn't account for food, clothing, utilities. Transportation is a big issue. If you don't have enough money, something has got to give. And women have to make choices every day about how they feed their families, whether they're going to pay the rent or the water or the electric. It can have a severe impact if they don't have that financial support to back them up.
Thank you, Sue Ellen. I love these watches. A question just came in, and that is, are we clear, and have we answered this question? I'm going to direct this to Walt, that if Amendment 1 passes, even if Roe stands, if Amendment 1 passes, is the immediate effect that women on Medicaid will not be able to get medically necessary abortions?
Not unless somebody wants to do them for free. I mean, that, you know, obviously it wouldn't, as long as Roe existed, it wouldn't affect someone if there was volunteers, but it would prohibit, clearly prohibit state funding for abortions because it would reinstitute West Virginia Code 9211, which has, I didn't read all of it because it's long, but limits abortions significantly under Medicaid, and that law would go back into effect.
Sorry for the reach there, Angie. Thank you. And I have another question for you, Angie, which is, to what time period are abortions currently performed in the state of West Virginia? What's the point in gestation?
Typically, most women who are seeking terminations are going to be seen in their first 12 to 13 weeks of pregnancy. I know of only one provider who will do terminations up to 16 weeks in West Virginia, so past 16 weeks a person would have to leave West Virginia in order to be able to receive services for termination.
16 weeks then. Okay, thank you very much. We're not to the portion where the audience is going to ask questions yet. We will be soon. Okay. I'm sorry, I've lost my place in my pages here. The next one was for Walt. And I will find it. There we go. Okay, Walt, would it be possible in the future, if Amendment 1 were to pass and Roe v. Wade were to fall, to prosecute a child who has an abortion, even in a case resulting from incest or rape? And the follow-up would be, who else would be criminally culpable in this hypothetical situation?
Well, yes. The short answer is yes. West Virginia Code, again, 6128, if Roe were to fall, would be in force again in West Virginia. And it provides that any person who administers, and I won't read it all again, anything that causes an abortion, so it's not limited to the person, it's not limited to the woman or child who has the abortion, but anyone who's involved in that could be prosecuted and convicted of a felony punishable by not less than 3 and no more than 10 years in prison, regardless of whether the child conceived through incest or rape or whatever.
So there's no lower age limit on prosecution?
The juvenile laws generally provide a limit of age, of legal responsibility, but that's not a bright line because minors can be prosecuted for instance, murder. Those under 18 down to a certain age can be, under certain circumstances, prosecuted for murder and other serious crimes. So there is a possibility under this law that a prosecutor could choose to prosecute even a minor for an abortion.
Thank you very much. My other question was for Angie. Would completely outlawing abortion in West Virginia, if we should get to that place, would that eliminate abortions in our state?
Unfortunately, no. Women who are set on terminating pregnancies are going to typically find some way. Whether it's an effective or safe way is the next question if it's not available through the safest channels that we currently have available. The risk of death from childbirth is 14 times higher than the risk of death from an abortion procedures for the mother. And so that, just to put it into a little bit of perspective, carrying a pregnancy to term is far more dangerous in terms of the risks involved compared to the safety of abortion that we have in this country today.
And how do medical associations here in the state and nationally, well, specifically regarding Amendment 2, how do medical associations here in the state of West Virginia view Amendment 2?
I know of, sorry?
Amendment 1. Amendment 1.
I'm sorry, Amendment 1, pardon me.
Correction. The the two organizations that I know what their positions are the American College of Obstetricians and Gynecologists. Their position is strongly opposing Amendment 1. And the organization that I belong to, I actually belong to the ACOG as well, but the American College of Nurse Midwives is strongly in opposition as well.
And one last question for you, Angie. Do you feel that there's a possibility that healthcare providers would choose to leave the state if this amendment should pass?
That's a really complex question too, but we did see a lot of healthcare providers leave the state when we had other issues that became legally difficult to practice in West Virginia. The most recent of which that I'm familiar with is the tort reform legislation that happened maybe 10 or 12 years ago. So yes, I think that is a definite possibility that we should be considering as we look at all the ramifications of policy change like this.
Okay, thank you. Did any of the panelists have anything else they wanted to add before we open the floor to questions? No? Okay. Please make sure that you are asking a question, and please speak clearly and loudly so that everyone can hear you. Okay. Ms. Camp had her hand up before, and then Judy.
Sue Ellen, how are you helping the young women that you work with to avoid unwanted pregnancies in the first place? Are you able to do that?
Actually, the Circles campaign just received a PrEP grant, which is a grant from DHHR, and we will be offering the PrEP materials as a supplement to our regular curriculum to those participating in our program, as well as offering it to various youth groups, and I don't have that information handy here in the community to help prevent pregnancies.
Okay. So PrEP is a sex ed program? Okay. And I believe the next hand was Ms. Pico.
I'm wanting to know on each level, what forms of birth control currently available would no longer be available if the Amendment 1 passes, but Roe versus Wade is not overturned, and then if Roe versus Wade is overturned, and I don't care who answers it.
Sounds like a good question for Angie.
It's my understanding that no forms of contraception would be more difficult to access than they currently are at this time. I don't think that it would make any changes as far as the legal issues for contraception, preventing pregnancy.
Yes.
I thought that some forms of birth control were considered abortive.
Okay. Yeah, let's talk about Amendment 1.
Not by any definition that I'm familiar with. Contraception means preventing conception, so any form of birth control, by what we usually associate as birth control, it's the termination of pregnancy that would be subject to Amendment 1. So that means a pregnancy that has already been conceived and established.
Okay, other questions in the back?
Yes, thank you. I want to ask Mr. Aldridge something. Question. First off, I want to say I thought you did a good job presenting the truth of the whole amendment. I'm in the state Senate, and I'm a co-sponsor on the bill. It doesn't mean I know nearly as much about all this as you do, but I think that a lot of the talk tonight, I'll get to a question here, has been a lot of straw man arguments, because all this Amendment 1 is about.
Excuse me, do you have a question?
I'm getting to a question. All Amendment 1 is about, am I right? There you go, that's your question. All Amendment 1 is about is going prior, back to Code 9-2-11, before Pinto, which gives the exception for the life of the mother, right? So we're having a long discussion here, a lot of straw men here on the life of the mother, when the life of the mother is a moot point in all this. Am I right on that?
Senator, I can't tell you how much I wish you were.
Well, I think I am.
I know you do, but you're not. And I'll explain it to you.
Okay.
Okay, so I was hoping to avoid reading this whole statute, but I think it's important now, given the question, because I do think that if it were limited to that, well, let me just step back from that and just make a statement about the more general issue, which is highly charged and highly emotional. And I have a feeling in this room, I probably am in the unusual position in West Virginia of being among people who probably more likely agree with how I feel than don't on this issue. That's not normal. That's not what I'm used to. And I have people that I love, that I'm very close to, and whose views I respect very deeply, who feel 180 degrees opposite of the way I feel about this whole issue. I respect them. I love them. I know they're coming from a place of caring and deep concern about life. I don't detract from that at all. So I want to start with that. So if the amendment were limited to the issue that the senator indicated, then the debate we would be having tonight would be limited to the question, and I don't want to dismiss it as an important question, of the degree to which we should protect women who can't afford access to abortion care with public funds. That is, I think, an important debate. It's a relevant debate. And it is part, correctly as the senator says, it's part of the issue that we have here tonight. But it is not, to me, I won't say the most important, it's certainly not the only issue. And here's why. West Virginia Code 9211, which is, the senator pointed out, is the 1993 law, says that no funds from the Medicaid program accounts may be used to pay for the performance of an abortion by surgical or chemical means unless, and then it provides exceptions, which the senator pointed out. On the basis of a physician's best clinical judgment, there is a medical emergency that so complicates a pregnancy as to necessitate an immediate abortion to avert the death of the mother, or for which a delay will create grave peril of irreversible loss of major bodily function or an equivalent injury to the mother, provided that an independent physician concurs with the physician's clinical judgment, so that's two doctors, or clear clinical medical evidence that the fetus has severe congenital defects or terminal disease, or is not expected to be delivered. I'm not sure what that means. I don't know. Possibly somebody else can explain that one to me. Or the individual is a victim of incest, or the individual is a victim of rape when the rape is reported to a law enforcement agency. Doesn't say anything about the incest. I'm not sure what that does. So, this is a whole bramble bush of issues, as you can already understand. However, understand that statute that I just read to you is the statute that was declared unconstitutional by the Panapinto decision, okay? You can understand and see from the language of that statute, it is limited solely to the issue of Medicaid funding of abortion. That's the only thing it affects. It's the only thing the statute affects. It's the only thing the decision affects.
That's what this is all about.
Well, if you were correct, I would agree, but it isn't, because the constitutional amendment which you sponsored and which was passed by the legislature and which we're being asked to approve, if it had read this as follows: nothing in this Constitution secures the right to the funding of abortion, you would be 100% correct. But that's not what you sponsored, and that's not what passed, and that's not what we're being asked to vote on. Instead, what we're being asked to vote on is nothing in this Constitution secures or protects a right to abortion, or the critical disjunctive of "or" means that the right is eliminated completely, and then we go on to say the funding is eliminated. Eliminating the right means that under West Virginia law, considering only West Virginia law, abortion is again a felony. West Virginia Code 6128, clearly.
Paid taxpayer abortions.
That's incorrect, Senator. I'll read you the statute.
Tax-paid abortions.
That's incorrect.
9-211 concerns taxpayer.
Well, to repeat, you're right, 9-211 does, but you've forgotten that you passed a criminal law that makes it a felony. 6128, abortion penalty, any person who shall administer to or cause to be taken by a woman a drug or anything, or use any means to produce an abortion or miscarriage, and shall thereby destroy such child or produce such abortion, shall be guilty of a felony.
Mr. Roe v. Wade gives the right for abortion.
Do you support Roe v. Wade, Senator?
That's a moot point. Roe v. Wade.
Well, it isn't a moot point.
Roe v. Wade gives, and I'll shut up. Roe v. Wade gives all women everywhere the right to an abortion. No state statute can overturn that. You know that, right?
Well, I agree with that, Senator. However, you're an ardent proponent of overturning it. And that's certainly your right, and I respect that. I respect that position, but you can't on the one hand say, don't worry, you're protected by Roe, and then stand and campaign to destroy Roe.
Well, I'm just making the point. I'm not saying don't worry. Obviously, I want to see you.
So you're concerned about a woman's right to choose as well?
I'm concerned about an innocent baby in the womb.
Well, I think that's a reasonable concern.
It is a reasonable.
It is a reasonable
But
concern.
all this does, just to clear the air, and
Well, if this were clearing the air, I would think it would be a good addition, but go ahead.
This amendment is about fundamentally going back to before Pinto to 9-211, which outlawed the state taxpayer use.
Senator, if you wanted to, no, Senator, if you wanted to do that, if you wanted to do that,
rape, incest, and life of the mother.
well, if you wanted to do that, why didn't you do that instead of what you did? What you did was to outlaw any right to abortion. That's what the law says.
Roe v. Wade gives you the right to it, doesn't it?
Well,
Are
but
you gonna railroad this whole thing, or, you know?
so I don't want to.
Well, I think that there are other people who have
Okay.
questions, and I think that you've gone on long enough.
Okay,
So I'm going to go to Mr.
but I do,
Shepherd
but
and
I
then to
want
Ms.
to.
Weber.
I do want to say I appreciate your input, Senator. I appreciate your
I
comment.
appreciate you, Mr. Roll. Thank you.
Mr. Shepherd and then Ms. Weber.
Hi, I've done a little bit of research on this before coming tonight, as I'm sure a lot of people have. And I have a letter here from Delegate John Schott, a man whom I respect a great deal, who's chairman of the Judiciary Committee for the state of West Virginia. And he has written this letter, and I've been provided to, it's written as to whom it may concern. And I had written to Delegate Schott about this. And so he mentions in here, and I wanted to ask Walt for his, the question is this. In Mr. Schott's letter, he says that if Amendment 1 is approved, that the passage of Amendment 4 will revive, unquote, a provision in state law, West Virginia Code 9-211, that was declared unconstitutional. And as much as I respect Mr. Schott and like him, as I look at that, and I look at 9-211, which I have a copy here of with the Panapinto decision, 9-211, as you've indicated, Walt, and I think it's the senator who's talks about how 9-211 theoretically protects a woman's right to abortion.
Correct.
Under a wide variety of things.
Correct.
But nonetheless, and I think this was your point, Walt, nonetheless, even though it makes those stipulations, the Supreme Court still found it was unconstitutional because it says it constitutes a discriminatory funding scheme which violates an indigent woman's constitutional rights. So even if we go back to 9-211, which Delegate Schott says that we will, and which I think that the senator here also indicates that we would go back to 9-211. 9-211 on its face was ruled unconstitutional by the state, and that would not necessarily, the passage of Amendment 1 would not necessarily re-invoke 9-211 in a way that makes a difference. Do you agree with that?
Actually, I wish I did agree with that, but I don't.
Okay.
And the reason I don't is because ultimately the organic law of the state is determined by the Constitution. The Constitution is determined in the first instance by the founders, and in the second instance by the voters through amendments. The amendment that we have before us would effectively overrule Panepinto and say that, yes, the West Virginia Supreme Court said what you just said, what Delegate Schott said, but we, the voters, disagree with that, and we're going to change the Constitution to say that Panepinto, in essence, it overrules Panepinto. So to that degree, Senator Rasinger is 100% right. So when he says, and so to the extent that he argues that Panepinto would be overruled and that therefore 9-11 would be back in force, my interpretation, and of course, I'm not a judge for many good reasons, but I believe that it would put 9-11 back in effect. However, the critical issue to me, Roger, is this. If the legislature had limited its role in this constitutional amendment to that issue, then we would be debating solely the question of whether we as voters in West Virginia want to remove the equal protection of medical decisions from poor West Virginia women or not. That would be the issue on the table. That is an important issue. It is an issue on the table. It is not, to me, the overriding issue. The overriding issue is when a woman, I mean, there are many issues, but to crystallize it in a factual pattern, which is quite common and which I have personal experience with. When a woman has an ectopic pregnancy and has a desired pregnancy, and she appears at an emergency room with pain, doesn't know what it is, she has a split-second decision to make. The doctors have a split-second decision to make about her life, and if you believe that a fetus is a life, the fetus's life. Fetus is not viable, cannot survive under any circumstances. This is not a theoretical thing. This happens quite frequently. Absent Roe, in the absence of Roe, that situation could very well result, if a woman chose not to terminate, if the doctor refused because of fear of prosecution to terminate, it would very likely result in the death of the mother. It would certainly result in the death of the fetus. Absolutely. Both would die. That does not seem pro-life to me. That is what this legislature has asked us to approve. So, that is not merely overruling Panepinto. I wish that it were, but it is not.
Okay, Ms. Weber had her hand up.
Yeah, I had a small amount of experience with Panepinto. I read through it when Amendment 1 came up, so I'm sort of trying to digest all the stuff that you all are talking about with that too. And I just want to make sure I understand. So with Panepinto, and everyone's saying, well, if this passes, that just means Panepinto goes back into effect. And that Panepinto just impacts women who are under the poverty line, yes? Just making sure I get it.
Well, I'll read the I don't know, it's a long decision, as you probably read, and it's kind of somewhat confusing, but in terms of all the language, but the gist of it, and I'm reading from this decision, given West Virginia's enhanced constitutional protections, and understand this goes back to this amendment, it is those exact enhanced constitutional protections which the Supreme Court found that the legislature, through this law, would reverse. So those would no longer be there. That's the core of the reason that would affect Panepinto. Given West Virginia's enhanced constitutional protections, we conclude that the provisions of West Virginia Code 9-11 constitute undue government interference in violation of the state's obligation, and this goes to your question, to act neutrally with regard to the exercise of the federally protected right to terminate a pregnancy.
So that doesn't, so is there the potential there that that could be, the stipulations under Panepinto could be applied to any woman trying to get an abortion in West Virginia? Like all of those different what if, then this position sort of things?
You've probably gone outside my area of competence, which is easily done.
And then I had a two-part, sorry. So why would the state legislation write something into our Constitution as a just in case? Like I'm having cover
No,
up
it happened the other way around.
No, I'm sorry, not with Pan Offense,
Oh.
this is with this amendment. So I keep hearing people saying, well, this is fine because you still have Roe v. Wade. Then what is the purpose of even putting it into our state's constitution if it's already a federally protected right? It seems sort of like they're building up into the potential hope that Roe v. Wade would then be overturned, and then we wouldn't have the right to an abortion in the state constitution, right?
Correct.
Okay, that's terrifying. Just checking.
Right.
I just didn't know
That's,
that was,
but, yeah, I mean, it's not a theory. That's exactly correct.
that's what it is?
Yeah, that's exactly what it is.
Okay.
Okay, we're gonna have people speak only once. You've already had a question, but we do have a hand back here and a hand here. Okay, and then over there. So 1, 2, and 3.
I think that kind of answered my question, but my question is, if nothing happens with Roe v. Wade ever, it stays there forever, and this passes, what does this do?
Well, it would be my belief that if Roe never changes,
Never ever.
big if, that in effect what this would do immediately is it would revert the state to 9-11
With Medicaid.
with Medicaid.
Okay.
That's the gist of it.
Okay, and I believe, yeah, Ms. Tuck had a question.
Well, what I hear you saying is that there's kind of two parts to this. Like, one is that nothing in the Constitution secures or protects the right to abortion, and nothing in the Constitution of West Virginia requires the funding of abortions. Two different things? I mean, two different, the or says this or that?
Correct. It's as though there were two different amendments, really. And keep in mind, this wasn't an accident. In the consideration of this amendment, there were, to use the phrase, and I know there's a lot of controversy about this, to use the phrase pro-life. There were pro-life advocates who urged the legislature to limit this amendment to the issue of funding. And the legislature absolutely refused. So, instead of limiting it to that issue, the legislature included two things in the amendment. One, which dealt with the funding. The other, which eliminates completely the state constitutional right entirely. So, yes, it's as though there are two things in one amendment.
Did you have a follow-up to that?
No, that kind of answered my question, because it seems like the right to abortion would affect everybody regardless of income. I mean, it affects not just Medicaid people, but every woman in West Virginia of childbearing age.
Yeah, I mean, it's a felony, again.
Regardless
For
of
everyone,
income.
yeah, absolutely.
Okay.
Again, but that felony prosecution is held in abeyance by Roe. So under West Virginia state law, understand we have two-tier jurisdiction in the United States. You're under the jurisdiction of the federal government and the state government. Federal government can prosecute you, the state government can prosecute you. Federal laws take precedence over state laws. So we can make it a crime to publish letters to the editor. We can make it a crime to do all kinds of things in West Virginia. But it can't be enforced because the federal government says you have a First Amendment right, you have an amendment right under Roe, you have this, you have that. Absent the federal protection, understand Roe's a 5-4 decision and has been for years. If that changes, criminal prosecutions of anyone for abortions in West Virginia would again be the law of West Virginia.
Roe was 7-2.
Okay. Another comment there, Sue?
Walt, I have another question for you. Wasn't it also true that the legislature also had the opportunity to include in this amendment exceptions for rape, incest, and to protect the life of the mother, and that was not included in this amendment?
Yes.
And then Ms. Cooper, and then back here.
In response to the motion to add exceptions to the amendment, they failed because in the state legislature, those exemptions, which are threats to the life of the mother, medical emergency, rape and incest, and fetal abnormality, are already included in the law. that will be
Excuse
revised
me.
once Amendment 1 passes.
Is this a question?
Well, that law is already on the books.
It-
Now, you can check on this, it's on the computer and everything, but that's why it failed. This is not going to make abortion illegal in West Virginia. It's
Go ahead,
just
Walt.
use of our tax dollars to pay for it.
Yep, we've covered this.
Birth control.
Right, we've covered that, but just again, if I could go back to that. I'm afraid you're under the misimpression that Senator Azinger's under, which is that the limited effect of the amendment, which I really wish you were right about, but you're not, that the amendment would only reinstitute West Virginia Code 9211, which I read, I won't read again. If it only had that effect, which, you know, you've correctly cited that law, if it only had that effect, you would be 100% correct. However, the amendment is not limited to that, and by its own language, and it's really not that hard to read, it clearly isn't limited to the issue of funding. It deals specifically with eliminating the right to abortion entirely. That then means that abortion would again be a felony under state law, under West Virginia Code 6128.
Only if Roe's overturned, right?
Well, yeah, as we've covered before.
But you didn't say that.
Ad nauseam.
Okay, I'm going to take one more question, and then in the interest of closing the building, because they like us to get out promptly before 8, we are going to wrap up the forum. So yes, please.
Hopefully this is simple. I'm really interested in the ectopic pregnancy because I didn't mentally go there. So normally with ectopic pregnancies, those require surgery of some type.
They don't always require surgery. They can be managed medically without surgery, but that would require a termination of the pregnancy because the developing pregnancy.
So if this would pass, and then under the funding part, then anything that would happen with an ectopic pregnancy would not be paid for?
That would be a really good question, challenging this. You're getting into the nuances, which as you can see are really complicated. And so yes, that potentially could eliminate that. I did a quick search for some information about the incidence of ectopic pregnancy, and it looks like, according to an article I found at the National Institutes of Health from 2000, which is fairly old, the incidence of ectopic pregnancy worldwide is on the increase from somewhere around 11 per 1,000 births, so that's closer to 1%, up to 18 per 1,000 births, which is closer to 2%. So just to put that into perspective, in West Virginia, we have under 20,000 births per year typically. We have approximately 5 million population. If this was
No,
going...
1.8.
Oh, sorry, 1.8. Thanks for that correction.
We wish we had 5 million.
That's not my specialty area, but pregnancies and births, I do know that that number is correct. It's
You
around
have some
20,000. And if the incidence is 1 per 100 women to experience an ectopic pregnancy as just one possible type of pregnancy complication that would necessitate a medical abortion, you can do the math as far as less than 2 million people, but we don't know how many pregnancies are conceived. That is not tracked in any measurable form. We do know how many terminations occur, we do know how many births occur, but there are a number of pregnancies that end through other means that would not be tracked at all.
Okay. I want to once again thank everyone for attending tonight and thank our panelists, and please help yourself to cookies on the way out. And thank you very much. We can have another round of applause for the panelists for sitting through tonight. Thank you.